Hello and welcome to the Beach House 34 podcast. I'm your host, Christine Worth. Welcome, new subscribers, and welcome back to our loyal listeners. If you are not yet subscribed, especially on the YouTube channel, please hit that like button and then click subscribe. It doesn't cost you a thing, and it helps the channel so much. If you're here, you know that I've covered the Darlie Routier Trial transcripts from the very beginning. We are finished with the actual testimony, and we've now moved on to the charge of the court and closing arguments. Now, in this episode, we hear from two attorneys for the defense team, Mr. Glover and Mr. Mosty. Now, before we get started with that, I want to point out that within the YouTube channel especially, there is an entire playlist devoted to every single piece of testimony that has been recorded in all of the episodes so far. And each of them are labeled in the order that you should listen to them to, if that makes sense. So anyway, I just wanted to point that out. I've organized all of that for you. If you want to start from the very beginning, it's very interesting. But anyway, let's go ahead and get started with Mr. Glover and Mr. Mosty and their statements. And this episode begins with the prosecution has just finished. The jury has taken a break, and it is now time for the defense. Once the jury is back into the courtroom, the court says, "Let the record reflect that all parties in the trial are present and the jury is seated." Mr. Glover. And Mr. Glover, he's not one that we usually hear from a lot, but he's for the defense, obviously. And he is doing this portion of the closing arguments, or at least in the charge of the court. And Mr. Glover says, "May it please the court." And the court says, "Yes, sir." And he continues, "Ladies and gentlemen of the jury, my thanks along with the other counsel in this case for your very courteous attention, these many weeks. As Mr. Shook said to you, we really have imposed upon you, but you occupy a position in our society, which is probably the most important, in that you are a barrier between what could possibly be, in a democracy, tyranny. And you make that decision, and you keep that tyranny away. And as we go through this case and we talk about the responsibilities of the government or of the state when they bring charges like this, you will see the importance of your position. You know, Judge Toll gives you a charge here. It's your guide as to the law that will guide you in this case. He tells you, and I think the most important thing that he tells you is that in any criminal case, charges are brought by the state. They have the burden of proof. That burden never shifts. And you know there is no burden on the defense to do anything. They are to prove her guilt beyond a reasonable doubt. And if there is a reasonable doubt as to any element in this case, the judge is telling you, you resolve that in behalf of the defendant and say by your verdict, not guilty. Now, you know, you can go through this evidence and you can say, well, you know, there was confusion about this. Or where was that witness? There was confusion about this particular evidence that raised a reasonable doubt in my mind. Judge Toll is telling you, you resolve that reasonable doubt in behalf of Darlie Routier and say by your verdict, not guilty. I don't care whether there was one or there are 1,000. The judge is telling you, you resolve those in her behalf. Let's go on and look at the evidence. And I am just going to speak with you just very briefly. Let's get to Mr. Cron. He was the bearded man who was a retired deputy sheriff in Dallas. He came out to the scene of this devastation very quickly that morning. He was put in charge, if you please. He tried to avoid that position, but he was put in charge. He waltzed through that house, folks, and in 20 minutes, without knowing anything, not knowing the result of any DNA, not knowing the result of any fingerprints, not knowing the result of anything. He waltzes through there and says, there was no intruder. The die was cast. She became the focus of everything. They wouldn't listen to anything else from anybody. There was nothing about black cars. They were secretly laying their groundwork to go after her. And they did. Now, what kind of flawed investigation is this, where the conclusion comes up front? He concluded it, folks. He said, there is no intruder. So, that's either Darren or her. And we know by the evidence in this case that only 2 millimeters she was away from death. And if she had died, according to Mr. And I'm going to pause here just for a second, in the transcript, and it's noted that it is wrong, but in the transcript it says Mr. Bentley, and I believe they mean the FBI agent, Mr. Brantley. So from here on out, it's going to be Mr. Brantley, at least on my side of things. So let me continue. That only 2 millimeters she was away from death. And if she had died, according to Mr. Brantley and according to Cron, do you know who would be on trial here? Mr. Brantley says the intruder knew those children, the intruder, Darlie, but I can't point the finger at anybody. But the person that killed those children knew them. Darren is just 2 millimeters away from being tried himself for this death. If she had died there on that couch, who would be out here being tried? Darren, according to the FBI. So how plausible is Mr. Brantley's conclusion about all of this? Mr. Brantley comes down to Dallas to lend sophistication, if you please, to what Mr. Cron has decided after 20 minutes. Mr. Cron waltzes through there and he says, oh yes, there is a torn window there. That is phony. But then experts come out there and they say the cut came from the outside, Mr. Cron. Well, that's all right. We will overlook that. And then as time goes by, they find fingerprints down here. And do you remember when Mr. Frosch, who was sitting out here on the front row, who never mounted that witness stand, came in here and gave a demonstration of going through the window, went right through it very quickly. He is a big man, and he put his hand, folks, exactly where those prints were found. Exactly where those prints were found. Now, of all the fingerprints that they attempted to find in that place, that was the most significant. They found very few, but that was the most significant. They matched nobody. Now, what does that tell you? Well, they want to dismiss that and try to infer to you that perhaps those were children's fingerprints. But isn't it interesting that Mr. Frosch put his hand right down there where they were as he went through there without any trouble? I submit to you, right through that window, and you saw it. They want to dismiss the sock up the alley. They want you to infer that through all of this melee out there, that Darlie Routier runs up the alley and plants a sock with the blood of both of the children on it. How preposterous. If you are going to create a scene and they have to have an answer for everything, anytime the scene gets confusing, they say, that's staging. You will recall Mr. Waddell, the first officer on the scene. He testifies, in lockstep with the position that the state has got to take it to back up Mr. Cron, his conclusion that she did it. She wasn't upset. You heard her husband talk about it. He said it was chaos. It was absolutely maddening what was going on there. She was from one child to the next, running around the room. The paramedics are pouring in there. They don't even know how many people came in there. The scene, and they keep talking about and using the word contaminated. The scene becomes very contaminated. The scene gets disrupted from the way it was at the time the crime occurred. And police officers do that to it. They want to come in and say that because the vacuum sweeper was over her foot, that she staged all of that, her print, or the glass down there on the floor. The first man on the scene, Mr. Waddell, says that vacuum sweeper was not in the way. That is something, folks, you would have seen. A vacuum sweeper standing in an area of importance in that house would have gotten your attention. Think about your vacuum sweeper being turned over in your kitchen. If you were a police officer walking in there, you would have noticed it. Mr. Waddell says, I didn't see a vacuum sweeper. And if you want any of this evidence read back to you as to the importance of that statement, ask the reporter to read that back to you. She can do that. Mr. Walling mounts the witness stand. I didn't see any vacuum sweeper. Darlie gets on the witness stand and says, I was using it as a prop. I was standing there trying to hold myself up. I want to talk with you just about one more subject, and then I'm going to sit down. You are going to have a question in your mind as to what you think went on out there that night when this happened. And I'm going to submit to you that it's a reasonable deduction from the evidence that you heard that that TV was on in there. And you all know from experience the kind of light that a TV creates. It's a dimming and it's a bouncing type of light. A person standing outside of that house could have seen that. They could have seen the silhouette of a woman lying on that couch, little knowing that there are two small children laying on the floor. And I can't put myself, and neither can you, into the mind of a crazed maniac, because that is what it would take to do this. But that person stealthily went into that house with the intention of going after her, gets in there, and sees the reflections on the floor of those two small children. And they want you to believe that would have been a noisy affair. How many movies have you ever seen where one adult dispatches another without even virtually a sound? It can be done, folks. And you are talking about two delicate little boys laying there on the floor. Do you think an adult male, or males for that matter, could not have come up very stealthily and leaned over each one of those kids and pinned them to the floor? And children are hard to wake up. And hold them down with their hand over their mouths or whatever is necessary to keep them from making noises, and plunge that knife into them. And that child would never have moved. It's like an animal and holding it down, and it could have been done without a bit of noise, and then move on next to the other child before you go for what you are ultimately in there for, the other adult, and stoops down over Damon, most close to her, and does the same thing. And do you think an adult male or males couldn't have held a little child down? It can be done, folks. Use your common sense as he has asked you to do. Then he moves on to her and cuts her throat. I don't know what his intentions were, but her panties were gone. She said that. We can't account for the mind of a person like this. Damon wakes up. Damon is not dead, and he comes over. And you say, why doesn't she hear all of this? Well, he is stealthily those two kids. And I don't know what he did to her, but I submit to you the account that she gave of what she felt in her mind as she came up off of that couch was one of a person who was in a complete fog. She said, I don't know. I just followed him out. The inside of her mouth was cut when she got to the hospital. Maybe he stuck something in her mouth. Maybe she momentarily lost consciousness as a result of being smothered. I submit to you that is probably what happened. Maybe he did beat on her. She doesn't know. She said, I didn't even know that I had been beaten on until those bruises showed up. The court says, you have used 10 minutes, Mr. Glover. Mr. Glover says, thank you, Judge. I'm going to sit down now, folks, but just as they say, and I adopt that, use your common sense. This woman did not kill those two little children. There is no evidence here whatsoever to indicate that she would ever have had that kind of mentality. Quite the contrary. And I will ask you sincerely, from my heart, to find her not guilty. Thank you. The court says, thank you, Mr. Glover, Mr. Mosty. And then Mr. Mosty of the defense stands up and says, may it please the court, counsel, ladies and gentlemen of the jury, I will just very briefly echo the thanks that you have been given by the other counsel. And, well, you know that we're thankful for your service. And I will apologize to you if at any time you think that I have wasted your time. If you think I have wasted the court's time, I apologize to the court. If you think I have wasted the state's time, I apologize to the state. But I'm going to expend every ounce of my energy to defend a principle I believe in and someone I believe in. And I will never apologize for my faith and my belief in those principles. But if I have done that too much in time-wise, I apologize. I'm sorry. There is no way that you can cover everything, but I want to focus back on a couple of things. My opening comments. Do you remember I said, and this is the phrase that I used, quote, by all accounts, this is an attentive, doting mother whose focus is her children, unquote. And ladies and gentlemen, you have not heard one word contrary to that. Even Basha, the one who comes down here, says she is faithful. They have a faithful marriage. They have a good marriage. She is attentive to her children. She is interested in her house. She is caring about her physical appearance. She wants her house clean. She has lots of kids in the house. All of these things are undisputed. They could not produce one person from Rowlett, Texas, who said to the contrary. Not one. And yet, then they say that there is a psychotic killer on the loose, claimed to be psychotic. And how many times did Mr. Shook say, quote, it doesn't make sense. Why did this happen? You know, that is the state's obligation. They cannot give you an explanation of what happened. They cannot tell you what happened. They don't know. And it's not our obligation to prove that. It seems to me like when you go back in this kind of case, and me not being able to cover everything I wish I could, but I know I'm going to forget. And there are some things I'm going to cover, and I'm going to sit down and I'm going to remember things I should have. But it seems to me that a jury in this case would sit down and very carefully and deliberately go through the evidence and look at some of these things. Some of these things have been pointed out to you quickly, and you need to get these pictures up and look at them. And I will point out a couple of things as we go through. I said in opening statement that Darlie Routier was in the crosshairs immediately. You know that is true. Within 20 minutes. You know, I want to get Mr. Cron in a room quietly, and I want to ask him, who do you think you are? Almighty judge, jury, and executioner? Who do you think you are that you walk in within 20 minutes and determine that this scene, that you know who is guilty? You don't know what the condition of anything is. You don't know what the story is. You don't know what the things were like when it happened. You don't know about fingerprints. You don't know about DNA. Who do you think you are? And from that moment, this case and the Rowlett Police Department was irretrievably, irreversibly, irrevocably focused in the crosshairs on Darlie Routier. And Cron said incredibly, I thought, I didn't need to pick up the glass. I didn't need to go to the FBI and see how much force it would take to break. Maybe we could have determined how it broke. I didn't need to do that. I didn't need to check officers' feet for glass because I knew there wasn't an intruder. I didn't need to pick up rags by the children's body because I knew that there wasn't an intruder. It seems to me like the first thing that you would do If you walked on a scene and you said, "This scene is not like another scene I have been to," what would you do? I would say, "Wait a minute, boys. This is the case we better be careful about. This one is unusual. This one is different. This one doesn't fit the pattern." And you know that in the mind of a crazed animal, in the mind of a drug crazed lunatic, what is going to make sense? And so, why don't you back up and say, "This is a case in which we need to leave no stone unturned. Let's do this one carefully. Let's don't decide in 20 minutes that we know what happened." But they did. And then what does the state do? The state, rather than bringing you hard facts, brings you opinions that cannot be tested. I'm not talking about medical opinions based on medical testimony. I'm not talking about scientific opinions based on scientific testimony. I'm talking about opinions that cannot and will never be tested. How much of the state's case is opinion? Cron's opinion? Well, we have got to back that up. So let's get Mr. Bevel in. Before I leave Cron, what is the one word that never came out of his lips? Sock. In the entire time he testified, he never said the word sock. Do you know why? Because he can't explain it. He cannot possibly explain the sock, so he didn't even mention it. It's like the glass, the wine glass. If it doesn't fit with my conclusion, I'm pushing it away. I'm never going to bring it to a jury. So we bring in Bevel. And Bevel is the blood guy. And do you remember when I was down here, and he demonstrates on the floor, and I said, well, first, he draws his opinion. And then he comes up with this video. And I encourage you to look at that video because contrary to what Mr. Shook says, in that video where he is doing like this, and he demonstrates, those blood spatters are long and there is clear directionality to them. As bad as that video is, you can see that. And remember, he says that Devin's stain, he can't tell you if it's going up or down. So what conclusion do you draw? But think about it. I'm down like this. And you remember I had my pen. I actually had the court reporter's pen, this green one. And I had like this, and I said, this one is going this way, and that is consistent with that? Well, yeah, that's okay. And this one is going like this, and that is consistent with that? Well, yeah, that's okay. And this one is over here as to like that? Yeah, that's okay. They are all consistent. There is nothing that he said that wasn't consistent except in his judgment, in his opinion. And remember what consistent means. It means I cannot exclude it as a possibility in his judgment. He can't explain how a bleeding person could get to that wine rack without getting blood on it. He can't explain it. He can't explain how a bleeding person can get to the vacuum cleaner without getting blood on it. He can't explain how someone picks up the vacuum cleaner 3 times, a woman 3 times, and doesn't have blood over here where he picked it up. He didn't want to admit that. Do you remember? He didn't want to admit where he picked it up. He can't explain that. But then he can explain a knife being laid down. Now think about that for a minute. Get the pictures out. You will see that that stain has a bend to it that goes with the knife. And he described laying it down. He described it as laying it down and leaving a trail and then laying it down. Ladies and gentlemen, if that is true, this trail goes straight. It does not go with the curvature of the knife. The other thing is, it was laid down left-handed. There, look at the photographs. It's right next to a chair. A right-handed person couldn't have gotten there to do that. It was laid down left-handed. And he goes and he tells you, remember back The state says that this scene is not disrupted. Bevel describes for you blood runs. Do you remember? Gravity blood runs. Ladies and gentlemen, take State's Exhibit 11. And I'm just going to demonstrate this for you, but do it for me. Over here on this coffee table, there is a blood run. There is a place where the blood has run. You see what I'm talking about? I may get in trouble for breaking this. It's on the coffee table right there. There is a blood run. That coffee table is askew, and there is a blood run there. I'm not going to be able to get it back to you. It's number 11. How does that blood run? If Darlie Routier is standing there, there is going to be a drop. However, if she bleeds there or someone bleeds there, I don't think that blood was identified and that coffee table is laid over, then the blood is going to run. That evidence shows you that at one point, that glass top table was off of the pedestal. That is how the blood ran. And it gets back up sometime, but the state and Mr. Bevel don't want to talk about that because that doesn't fit with their theory. Bevel, and you can give him credit for this sock stuff. Bevel said that the sock that is disconnected or disassociated evidence. I can't remember what he called it. They said, Mr. Bevel, if you were going to disassociate something, would you disassociate a sock? Of course not. You would disassociate a murder weapon. But that is how the state, when something doesn't quite go right, we wiggle it to try to make it meet our preconceived answer. And Charlie Lynch, and again, to some extent, I have got to include Charlie Lynch in this question of opinions, where I say opinion that is unfounded. I don't quarrel with what Charlie Lynch said his job was. You remember, he said, my job is to tell you what I see and to leave it to you lawyers. He told me this, to leave it to you lawyers to figure out what it means. That is what he said. You all remember it, sort of a humorous moment. And of course, he was describing in some of that the fiberglass. And remember that his fiberglass experiments, in all of his experiments, he got 3 to 4 times more glass rods than he found on his knife. He said, I can't marry those two. I can't bond them together. There could be any number of other things. He looked at one circuit board. He didn't test any circuit boards. He said he picked up one. He didn't test it. But then what Charlie Lynch said is fall in lockstep with the state. He comes up with an opinion that is not verifiable, that is not scientifically or medically recreatable. He comes up with a theory that this must be posed. Well, when did Charlie stop being an observer of details and start being an advocate for the state? When did he stop? And that is where you get into these opinions. And then to cap it off, the state brings a bureaucrat from Washington who has been to one murder scene in his life. First, the state sends him what they want. Their reports of these officers who are not under cross-examination, these officers who didn't make a report, sometimes who made supplemental reports. The only person in this courtroom who has got to have a perfect story is Darlie Routier. All of these officers can make supplemental reports and they can forget who picked up the sock and they can do all of this stuff and it's simply a mistake. I mean, memories are like that. But Brantley comes down and gives you a mail-in verdict. The state has mailed him what they want in Washington. They know the lady is indicted. He knows that Cron has said she is guilty. They send him the tests that they want to send. They send Dallas Morning News articles along with it, and he mails back a verdict. That is the antithesis of the jury system. He comes down here and he says, based on what I have looked at, all he did was get under oath and deliver the state's final argument for them. That's all he did. He Could I hire that guy? No. He works for the FBI. Can you challenge that? No, not based on reason. He thinks the room is not askew enough for him. Well, he didn't know this coffee table had been knocked over. The trash cans are knocked over, but not enough to suit him. And again, saying, why did something happen? Or is this, I wonder why? What is the reason? That is not proving facts beyond a reasonable doubt. It's an untested opinion. Judge Barton, who was the judge before Judge Abels, I don't know how many cases I have tried in this courtroom, but I will never forget this. When a jury was let go, no matter what time of night it was, and Judge Barton worked long hours, we had lots of verdicts at midnight. And he would invariably bring the jury in, and they were tired and they were worn out, and the lawyers were tired and the lawyers were worn out. And Judge Barton would invariably tell them this story that I thought was silly. And I thought, Judge, come on. And he would say, ladies and gentlemen, in this country, you have the right to participate in the jury system. People, ordinary citizens, have the right to participate in the jury system. And so long as that happens, he would tell them there are going to be fallibilities because people are fallible. And the system is not perfect because people work in it. Juries work in the system. But, he said, the only perfect system is one in which the people are not allowed to participate, in which the government chooses to decide who is charged and what evidence and who is guilty, and the people are not allowed to participate. And so he would say, be thankful that you live in a system where the people can participate. And I say thanks to Judge Barton. It took me a long time to learn the importance of that, but I know it. You know what Brantley didn't talk about? That black car. Is there one lick of evidence in the record that anybody ever looked for that black car? None. It's described by Basha. It's described by Helena. It's described by the Neals, and Nelda Watts described it to Mr. Patterson. 4 times that black car shows sitting in the driveway, watching the house, and there is not one lick of evidence about it. The state wants to disconnect that, like they want to disconnect the sock because they can't explain it. They can't explain a pubic hair. They can't explain a fingerprint. They can't explain those things. So they want to say, this is a confusing situation. It doesn't make sense. It's their obligation to make it make sense. Like Mr. Shook said about motive, people want to know why. Do you know why people want to know why? Because some things don't make sense. It makes no sense that this lady would change from a good mother, a doting mother, to a psychotic killer. So that lack of motive, that lack of reason creates hesitation. That is what reasonable doubt is described as. Hesitation when you are acting on the most important things in life. The state tries to bring in, for instance, these records. Again, go look. Mr. Davis, the state, has tried to mislead you on sometimes and call them on it. Mr. Davis offered the January through May bank statements and said, you are nearly $3,000 less in deposits than in your withdrawals. Well, of course, in June, that situation reversed itself. But you know what they forgot to tell you? You know what he forgot to point out to you? Is how much money the Routiers took out of that business for their own uses. More than $5,000 a month in draws from the Routiers. Look at it if you want to. That is the average, $5,200 plus another $1,000. They paid for the Nissan, $400 out of there. They paid for the boat, $344. Their insurance was $272. Over that period of time, they were taking $6,700, $4,100, $5,300 out. And do you know the month of May? The month of May draws of $7,000. Do you know why? Do you know why these things were in the trash can? Because they have been taken care of. The draws are $7,000 a month, plus another 1,000 on cars and payments like that. The reasons added up. I can't remember what it is. It's something like $35,000 that the Routiers took out of that business, and the state misleads you about these records. That, someone contemplating an important event, like someone who is going to kill their children, is going to get these records out. Well, they didn't even get them out. They are dog and cat records. They are life insurance papers. There's old notes. There's a letter from a lawyer months before about a will. Those are all of what is sitting up there, and that is what is sitting here. The state doesn't want to talk about those because they can't. They don't get anywhere. They are innuendo. Did you hear some of the innuendo about, do you take your children to the pawn shop? Gangster's paradise? What do you think Mr. Davis would say if Mrs. Routier played her favorite song at her children's funeral? What do you think he would say? He would say, you care so little about your children, you won't even play their favorite song. Who do you think you are? The state. Another thing the state doesn't want to talk about, the towels. The state doesn't want Darlie Routier over there by the children. Well, ladies and gentlemen, look at Exhibit 56. It's got blood by Devon's body. Blood drops. Whose blood is that? It's Darlie Routier's. If she didn't go to help Devon, how did that blood get there? The state doesn't want her bringing towels. Look at Exhibit 79. It's the towel drawer. It's open. You see the kind of towels that are in evidence. There is blood on the drawer. Whose blood is it? It's Darlie Routier's. If she didn't get towels to help the children, how did the blood get there? If she didn't take the towels, do you think she stood in the kitchen and threw them to Darren? How did the white towel? This isn't it. They didn't pick up the one by Devon. How did those towels get to Devon? By his hand? And the court says, you have used 25 minutes, Mr. Mosty. Mr. Mosty says, I'm going to talk briefly about, and Mr. Mulder will cover this more, the knife wound. And I'm going to relate this to Mr. Brantley. Did you notice how Dr. DeMaio described those wounds and how they came down and then in a continuation? And common sense tells you, and anybody who describes these sees how you would do that. And the length of the knife. Think about that. How could someone cut in the manner that Darlie is cut up? A right-handed person? Look where the knife has to be. And how do you get this wound over here? It doesn't make sense. It doesn't make common sense. And that is medical. That is a medical opinion. It's not some witchcraft opinion from the FBI headquarters. It's medical. How do we get these bruises? The state, if Darlie Routier was out in a long black veil at the gravesite, they would say she is faking it. If she had a perfect story, they would say that is too good. There is no way that it can fit. There is no way this knife wound can fit logically. There is no way the sequence of events can fit logically. And what did the state do through all of this? I cannot imagine someone being more under a microscope than Darlie Routier has been. She started at 6 a.m. when they go down there, and she is on disinhibiting drug. I submit they knew that, and they thought they are going to go down there to the hospital, and they are going to find out what went on. And then, to be good guys, they go and visit her on the 7th. And then on the 8th, they come and they get another statement. 10 pages. Remember, ladies and gentlemen, when you talk about these bruises, how did she leave the hospital? In the escort of the Rowlett PD. She goes, and all of these bruises are described by any number of people. And then after that, They see her again on the 10th, take pictures again, talk to her again. And then, who do you think you are? To go out and put a bug on a gravesite in hopes that you will get a confession. Who do you think you are? You know, the only person who needed a lawyer, one needed to claim a lawyer in this case, you heard him, was Officer Patterson. If you are going to ask me about that, I'm going to talk to a lawyer. The audacity to do that at a funeral service, at a prayer service for children, and then to bring in the closer, Mr. Parker. 3 hours. Close the deal for us. Close the deal. Mr. Parker says, well, in that deep voice, don't you know how he came across to Darlie Routier? He says, she didn't deny it. Well, Mr. Parker, she told you somebody else did it, didn't she? That is denial. And after 3 hours in there, can't you see her saying, man, leave me alone. You accused me. You told me you thought I was guilty. You told me you looked at all the evidence. You told me all that. Leave me alone. Now, then beyond that, they copy all of her jailhouse mail, and through all of that, through everything microscopically that they have done to Darlie Routier, what is the one thing that they have failed so miserably to do? Get the confession that they wanted. Get the confession that they bugged Graves for. Get the confession that they brought the closer in for. Get the confession that they read the jail mail for. They didn't get any of it, And here is a lady sitting in jail whose investigators and lawyers are out there, and they are trying to say, gosh, we've got a lead. And she gets beat up over that. Good night. But they never, ever got what they wanted. And they never, ever have brought you an explanation. Mr. Brantley, Mr. Mulder said, Mr. Brantley, from all the way from Washington, here is your chance. Tell me what happened. He couldn't do it. Tell me how it happened. He couldn't do it. He didn't know. There are things he said he didn't know. He didn't know DNA results, for one thing. He didn't know when the children died or how long they died, even though the autopsy report was available to him. He didn't want to know. He was afforded the opportunity to set it out, and through this trial, no one has done it. And I submit to you that they never will. There is no way I can cover what I would like to cover. But it is so important that you go back and you look at the evidence, at the hard facts, at the verifiable medical evidence, at the verifiable scientific evidence. All of the state's case of opinions, of maybes, of could be's, of could have been, should have been, would have been. That is not proof beyond a reasonable doubt. That is not a could have, should have, would have. This is not a case where you say, well, if she didn't do it, who did? This isn't a multiple choice test, or as we used to call them, multiple guess. This isn't multiple guess. This isn't a question of you solving the case. I think we talked to every one of you on the jury about that. You are not here to solve the case. This is a question of, has the state brought you hard evidence, verifiable evidence, that would cause you not to hesitate in your life? That is the definition of reasonable doubt. Not to hesitate to make that decision. If you hesitate, then you have got a doubt based on reason, not opinions, not just, oh, I think this, or that is consistent with this, or this is consistent with blood going that way. This blood drop could be going up or down. That table is not messed up enough. Proof beyond a reasonable doubt. And I say to you that when you are back there and you are debating this thing and you move from subject to subject, remind yourself, remind your fellow jurors, we have to test this piece of evidence against the presumption of innocence. Every piece of evidence tested against the presumption of innocence. Every time you are in a conversation with your fellow juror, you seem to hesitate about that. You seem to have reasonable doubt about that. Work through it and think about it. There is no explanation. The state has failed miserably, as Mr. Davis said in the beginning. We're going to tell you why this happened. They didn't do that. They proved it's just the contrary. A mother, that there is no explanation and they will never give you one. And they will never give you an explanation of what happened that night. You know, and I bet the officers who walked on the scene when Charles Manson had butchered those people said, I have never seen anything like this. And as Cron said, the FBI who fingered Richard Jewell, I bet there are a few places they would say, I have never seen anything like this. In closing, I want to quote two things. Justice Brandeis was one of the eminent Supreme Court justices for many years, and he wrote in 1928, nearly 70 years ago, in a case called Olmstead versus the United States. Quote, they, the makers of the Constitution, conferred us against the government the right to be let alone, the most comprehensive of rights and the right most valued by civilized men. The greatest dangers to liberty lurk in insidious encroachment by men of zeal, well-meaning but without understanding. Unquote. They don't like Darlie Routier. They don't like the lifestyle she led. They have to try to trash her with breast implants. Why did they do that? They want to trash her because they can't explain it. The court says, you have used 35 minutes, Mr. Mosty. Mr. Mosty says, she had the audacity. She had the audacity to express herself the way she really is, and the audacity to not fit what the state, what the government wanted her to do, and to be the victim of a crime that doesn't fit what somebody in Washington thinks it ought to look like. Learned Hand was a justice of the Supreme Court for many years, and he made a statement that I have adopted as my own. The quote was first written by Oliver Cromwell to the Church of Scotland in 1650. And he is writing to the Church of Scotland over, at that time, a religious issue. And he says, I beseech ye in the name of God that ye may be mistaken. And Learned Hand, in his articles, Life and Morals and Ethics in Public Life, made this quote. He said, I beseech ye in the name of God, and ye may be mistaken. I should like to have every school begin. I should like to have every legislative body begin. And yes, I should like to have every court begin with this statement. I beseech ye in the name of God that ye may be mistaken. And I should like for every jury, when you are weighing reasonable doubt, when you are laying the evidence against the presumption of innocence, when you are seeing if you hesitate and if your fellow jurors hesitate in the most important of life's events, I beseech ye in the name of God that ye may be mistaken. Thank you. The court says, thank you, Mr. Mosty. Mr. Mulder then says, Judge, if we could have just a minute to organize the evidence. And the court says, all right, if you will, step back in the jury room for a brief 5-minute break, please. And this is where we are going to end at this moment. And then we will pick up with the statement of the other defense attorney, Douglas Mulder. So let's do a really, really quick recap. The episode begins with Mr. Glover, someone from the defense team we haven't really heard from a whole lot before. I don't even know if we've heard from him at all. But anyway, he goes straight into criticizing the fact that Cron had decided within 20 minutes that the scene was staged. And from that moment on, Darlie was in the crosshairs. He also talks about fingerprints that were ignored, how the sock that was found in the alley was barely talked about, and then questions whether or not that FBI agent, Brantley, had all of the information he actually needed in order to form his opinion. So Glover essentially suggested that the agent's opinions were solely based on only the information that the state had given him. and that he didn't actually receive the full picture. Mr. Mosty then gets up to address the jury, and he focuses his arguments based on the fact that even though plenty of people saw this black car, it was never investigated, and makes some pretty good points also that no matter what Darlie did or how she acted, whether it was at the funeral, at the gravesite, what music she chose for the funeral, no matter what she did, the state would have found something wrong with it. And yes, I agree with that. We still have to hear on the defense side from Mr. Mulder, and that will be in the next episode. So that will do it for now. Thank you all for listening. The next episode will actually be available in a couple of days for you to listen to. And don't forget to subscribe to the channel no matter where you listen, and we will talk very soon. Bye for now.